Taste the Daily.
Destroy the evidence. And in any case, by the very nature of the power under 17A, which is purely executive and administrative in nature, Lord, no hearing is necessary. Lord, for that, my Lord, I wish to, my Lord, cite Subramaniam Swami, my Lord, at page 27, para 36 at the foot, my Lord. They have also cited, but, my Lord, this is the true ratio which is applicable in the present case, my Lord. My Lord, in fact, this has been conclusively settled in state of Maharashtra versus so-and-so, that sanction to prosecute the chief minister is the exclusive function of the governor to be exercised by him in his discretion, followed by the decision in case of Dr. J. Jayalalitha versus so-and-so, wherein it was further amplified that it is erroneous to say that the view of the Supreme Court was based on a concession made by counsel, and the perusal of the relevant part of the judgment shows that the court has expressed its opinion that such concession was rightly made. In the present matter, the allegations and the material in support of allegations would prima facie indicate that the said land was given to SC person by due course of law. The record of the said land was transferred from the father to children, and again from children to father. This mystery was not considered by the state cabinet. When the notification, now he says why I'm not relying upon state cabinet. First he says that even as per law, I'm supposed to use my own discretion, not aid and advice. Now he goes further. State cabinet, when the notification for land acquisition issued and the denotification order was issued, Shri so-and-so was the member of Legislative Assembly from so-and-so constituency, as well as a member of Mysore Urban Development Authority. And further, this land was purchased by a brother-in-law of Shri so-and-so, wherein the seller was from the constituency of so-and-so, and later on after getting the land converted into the residential purpose, gifted it to the wife of Shri so-and-so, who became the owner of the property, and the application for allocation of alternative sites came to be moved on the basis of relinquishment of agricultural land. On the basis of this application, MUDA passed the resolution pursuant to the amendment to allot alternate sites. It has been specifically averred that the rules was specifically amended, averred in the complaint. He is giving a prima facie consideration whether a cognizable offense is made out, which needs investigation. A rule was specifically amended from 40-60 to 50-50 to aid this transaction where so-and-so was the chief minister. Further, the petition seeking grant of sanction for prosecution and material provided clearly indicate that Sri so-and-so, son of Sri so-and-so, participated in MUDA meeting, which resulted in allotment of alternative site in very prime layout called Vijayanagar. These facts were placed before the Council of Ministers. The aforesaid brief facts, when correlated with the material in support of grant of sanction, clearly establish that there is apparent bias in the decision taken by the Council of Ministers in favor of Sri so-and-so. Due to this apparent bias, the present matter requires my independent application of mind to the petition seeking grant of sanction for prosecution and the material in support of the same. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri so-and-so was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media and newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land, and irregularities in allocation of land. Further, the constituting a committee under an IAS officer and immediately constituting one-member committee under a retired judge of the High Court, and the government's own acceptance that there is potential big-ticket scam in allotment of sites by MUDA does not inspire much confidence. It is well settled legal principle that the persons against whom allegations are made should not be empowered to decide the course of action. Even after such grave allegations being involved in the present matter and the fact that materials prima facie supports the allegations, therefore the decision taken by the Council of Ministers is irrational. Well, this is what MP judgment says, that if it is found that it is irrational or vitiated, biased, or other considerations I'll come to, my lord, then the governor will have to act at his discretion. As even after the appointment of high-level single-member inquiry committee on such serious allegation, the Council of Ministers do not consider the entire material in support of the allegation. The subject of binding of the advice of the Council of Ministers for Governor and discretionary power of Governor during special circumstances is well discussed and decided in case of Madhya Pradesh Police Establishment versus so-and-so. The 5 judges bench of the Supreme Court has held that if on these facts and circumstances, the governor cannot act in his own discretion, there would be a complete breakdown of rule of law in as much as it would then be open for governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. If in cases where prima facie is clearly made out, sanction to prosecute high functionaries is refused or withheld, democracy itself will be at stake. This is one quotation from the Supreme Court judgment. It would then lead to a situation where people in power may break the law with impunity, safe in the knowledge that they will not be prosecuted, as requisite sanction will not be granted. On the point raised by the Council of Ministers that an application for previous approval under Section 17A can be made only by police officer and not by a private person. My lord, something which was unfortunately argued by the petitioner, despite, and I will come to that, a very fair and correct legal opinion given by the learned Advocate General saying that no, this is not true. It is not. Any private individual is also, yes, as held by your lordships, bound to approach.
It is only investigation and inquiry should not commence by a police officer without approval.
Exactly, but
it is not that he should seek approval. There is no law that he only should seek approval.
Yes, but that was...
Approval can be sought, definitely. That's what I have also held. Approval can be sought by anybody. Approval, setting the criminal law into motion, it can be by anybody. So this is what requires is 17A. Correct. 17A, and approval can be sought by the person who has sought to set the criminal law into motion. Any person. No officer shall investigate what is said in 17A is only without approval he shall not investigate.
Even the
he need not seek.
If I, as a private individual, because in a criminal jurisdiction, jurisprudence, there is no concept of locus standi. Anyone can...
anybody can set the criminal law into motion.
But if I go before the court invoking, my lord, the powers of the court to issue process or issue a direction akin to the old section 156(3), then I'll need that approval under 17A. Otherwise, even court cannot direct.
That's all. That approval should be there for a police officer to inquire or investigate.
My lord, therefore, my lord, to be very fair, my lord, to the Honorable Advocate General, in his opinion, he says that, relying upon your lordship's judgment, that no...
What I have myself held.
Yeah, yes, my lord, he relies upon, but unfortunately, the petitioner still continue that no, it can only be the police officer. My lord, therefore, I'm just reading that even that is considered by the Honorable Governor. Provides the police officer and not private person. Section 17A of the Prevention of Corruption Act provides that no inquiry or investigation shall be conducted by a police officer into any offence alleged to have been committed by a public servant under the PC Act without prior approval from appropriate authority. However, neither it is said that private person cannot request for the prior approval from the competent authority, nor only the investigating agency will seek the sanction from the competent authority. The only thing is to understood that the police will not inquire without prior sanction. It is important that police should start the investigation process only after getting the sanction from the competent authority. It is immaterial who does the effort to get the sanction. The decision of the Honorable High Court of Karnataka in so-and-so, Dr. Ashok, my lord's judgment. Yes. What more application of mind can a governor, my lord, make? Is expected to make at a 17A stage. But since it was a contention raised by the Honorable Chief Minister, he deals with this. So-and-so and various high courts, the High Court of Karnataka had issued guidelines to be followed in the cases related to prosecution of public servant for the alleged offences during the discharge of duties with a circular dated so-and-so. This circular stipulates the procedure and prerequisite for registering the cases of prosecution against the public servants. Point number 2 of the circular reads as, my lord, your lordships have read that circular, I'm not, my lord, reading. Hence, last 2 lines, the above circular of the Honorable High Court makes it compulsory that previous sanction is necessary to file a private complaint in the court of law by private persons. In view of the aforesaid, it emerges that the present situation amounts to peril of democratic principles and therefore requires independent application of mind and my subjective satisfaction and objective assessment of facts and materials provided. Since the sanction is sought against the Honorable Minister himself, Chief Minister himself, the surrounding circumstances of placing the show cause notice before the Cabinet and the decision of the Cabinet advising me to withdraw the notice would not inspire confidence to act on such advice of the Cabinet. So why he is not following 163, my lord, is also recorded by applying mind. Upon perusal of the petition along with the material in support of the allegations in the petition and subsequent reply of Shri so-and-so and the advice of the State Cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It is very necessary that a neutral, objective and non-partisan investigation should be conducted. I am prima facie satisfied that allegations and supporting materials disclose commission of the offences. Then, my lord, at the end, he says 32. Hence, I hereby accord sanction against the Chief Minister under Section 17A of the Act, read with 218 of so-and-so for the commission of the alleged offences as mentioned in the petitions. My lord, petition mentioned two things, 17A and 218. 218 is 197. My lord, which is not the stage here.
Yes.
So this will have to be confined to 17.
197 is precognizance.
So
sanction.
precognizance after investigation.
Investigation.
And, my lord, thereafter, my lord, the order is passed based upon, my lord, this material, which is on, my lord, page 1. Your lordships were taken by my learned friend, Mr. Singhvi, to the order, my lord.
The order?
Well, the impugn order. Impugn order, my lord. But this is the impugn order, my lord, thereafter according sanction to court. And, my lord, this is the Honorable Governor signs on 16th August 24, the entire detailed, my lord, consideration. And on the same date, on 16th August, the impugn order is passed according approval. And I'll show that all findings, all considerations, all application of mind need not be in the order. It should be reflected on file, and the court's conscience should be satisfied that there is an application of mind. Lord, when I am meeting with the allegation that the Honorable Governor did not apply mind, my lord, let me show something very interesting. The application of mind and why the Honorable Governor was fully justified in not relying upon the aid and advice. Well, there are 5 stages. I'll just tell your lordship broadly and just, my lord, show. The first is the Chief Secretary prepares a note that these are the facts of the case, say 40 pages. My lord, I'm giving an hypothetical, it would be 45 or whatever.
Yes.
Or 20 or whatever. My lord. Thereafter, matter goes to the learned Advocate General for his opinion. The learned Advocate General, my lord, obviously takes those facts as they are. I'll not say copy because we always, my lord, take the facts as given to us, my lord, from the officers. Then adds his opinion, judgments, etc., etc. That is the second stage. Third stage, the matter is placed before the Cabinet. Cabinet, in this 90-page Cabinet note, verbatim, with comma full stop, reproduces the opinion
Of the Advocate General.
of the Advocate General and the Chief Secretary. Verbatim, comma, full stop. Lord, constitutionally speaking, the Cabinet is collectively responsible, but this is a case of collective non-application of mind. Everyone, my lord, agreed to something which is pre-written, page to page. Thereafter, my lord, the fourth stage comes, and fourth stage is the reply given by the Honorable Chief Minister, which is cut paste from Chief Secretary, Learned Advocate General, Cabinet note, That forms part of his reply. And the last para, that in view of this, don't grant sanction. And the fifth stage, the petition contains those averments in that order, seriatim, page by page. Lord, irony, Bangalore is an IT capital of the country. There is an artificial intelligence available. They could have used artificial intelligence to at least paraphrase what is being copied. But, my lord, they say on a lighter side that artificial intelligence can never match natural stupidity. But this is, my lord, the collective non-application of mind, my lord, and I have dealt with, my lord, a reasonable application of mind by the, my lord.
This is the first point.
Yes, this is my
application
first
of
point.
mind.
Yes.
No, I think even natural justice you dealt with or still to tell?
Yeah, no, my lord, I have something more to add, my lord. Lord, please come to page of my note, my lord. Please come to Lord, page 19, page 18, because my learned friend may.
80.
Only a minute.
Yes, yes.
My lord, my learned friend may raise a ground, a potential submission which I may deal with right now, that whatever is the application of mind should be reflected in the order itself, and you cannot justify it by file notings. The Honorable Supreme Court had an occasions to deal with such a submission.
Nambudri Park.
Yes, my lord, not required.
1990.
Yes, I'm grateful, my lord.
Where the
Kindly
Supreme
have a
Court
look
says if the reasons are found in the file notings, that would suffice.
Enough.
Because it was also a case of a chief minister.
Yes, my lord. Kindly, my lord, have a look at, but just to give a flavor of that judgment,
Have the
page
judgment?
18, my lords.
Have the judgment?
No, my lord, page 18 of my note. I have quoted the relevant part.
Yes, sir.
Page 19, my lord, is the judgment, para 22.
A.G. Nambudri, yes.
Yes, A.G. Nambudri, my lord. It is submitted that in order to understand the reasoning of the decision to grant approval for sanction, the perusal of, this was also grant of sanction, pre-cognizance section. So something at a higher threshold.
After investigation.
Yes, after investigation. 17A is at a much lower threshold. The perusal of the file is necessary. It is stated that same is a permissible mode of examination of the extent of application of mind and locating the actual reasons behind the order. In case of Union of India versus E.G. Nambudri, please turn the page over, my lord. I'll read, my lord, only what is relevant, because I know, my lord, your lordships need not be bothered with what is, my lord, very obvious. Your lordships are fully aware, but only highlighted part. If any challenge is made to the validity of an order on the ground of it being arbitrary or mala fide, it is always open to the authority concerned to place reasons before the court which may have persuaded it to pass the orders. Such reasons must already exist on record, as it is not permissible to the authority to support the order by reasons not contained in the records. Like my lord Mohinder Singh Gill case, that you cannot substantiate your order by filing affidavit subsequently. But the reasons are already pre-existing.
So the submission is in Mohinder Singh Gill, there was nothing in the order nor in the file. It was sought to be justified by way of statement of objections, which the Supreme Court said it cannot be done.
It cannot be done.
Now what you're saying is that everything is in the file. It is not that it should be in the order.
It existed when the order was passed.
Existed.
Then para 10. In governmental functioning, before any order is issued, the matter is generally considered at various levels and the reasons and opinions are contained in the notes on the file. The reasons contained in the file enable the competent authority to formulate its opinion. If the order as communicated to the government servant rejecting the representation does not contain any reasons, the order cannot be held to be bad in law. If such an order is challenged in a court of law, it is always open to the competent authority to place the reasons before the court which may have led to the rejection of the representation. It is always open to an administrative authority to produce evidence, elucidate before the court to justify its action. I cannot file an affidavit and supplement it by new reasons, but I can always show that reasons already existed. And summary of those reasons is
Forms the part of the order.
forms part of the impugn order. My lord, similar in case of my lord Sarath Kumar Das. My lord, kindly see only the highlighted part. The record is called to consider whether he has given due consideration to the facts placed before him before he arrives at the decision. Therefore, the reasons in the order or found from the record bridges the link between the maker of the order and the order itself or decision. Therefore, the natural justice is not a rigid nor an inflexible rule. It should be applied to a given fact situation depending upon the background of the statutory provisions, nature of the right which may be affected, and the consequences that may entail. This court held that the grading itself is a reason and no separate reason in that behalf in arrangement, or that is on the facts of the case. So, my lord, it is not providing reason post decision, but showing
Reasons
something
existing
pre-decision.
pre-decision.
Then, my lord, page 22, I have quoted, my lord, again Sri Rupa. Lord, where only para 30 and 31, my lord, may perhaps, my lord, I would
Yes,
like to assist your lordship with.
Yes, sir.
It is therefore not necessary that there should be clear incriminating evidence with the investigating officer at the stage of him seeking prior approval under 17A. My lord, here was the facts where
There, no,
he
Lokayukta was
started on it.
complaint.
He started on
The
his own.
Lokayukta was, the complaint was made to the Lokayukta. The investigating officer had sought approval under 17A. It is in those circumstances it was written.
All that is required under the provisions of section 17A of the Act is that the investigating officer has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. This is all the complainant needs to do, and this is all the Honorable Governor needs to examine. 31, my lord. Since the public servant is yet to be investigated, the question of considering any incriminating material and coming to the conclusion that an investigation is unnecessary would not really arise in this particular case. Since the public servant is yet to be investigated, the question of considering whether there is any incriminating material or its veracity by the state government to come to the conclusion that an investigation is warranted or not would be untenable and stand no logic or reason. At this stage, it cannot be done. He is yet to be investigated by the Lord. Then page 23, para 49. The argument that the materials collected have to be considered meticulously. My learned friend, my lord, in substance, I am paraphrasing his submission, said that the order granting approval under section 17A should be akin to a judgment of the court, dealing with each and every submission made by the Honorable Chief Minister. No, this is purely an executive administrative order. It need not contain para-wise para, contention-wise contention findings, because that would be counterproductive to the very intent of section 17A. That, my lord, this Honorable Court says, the argument that the materials collected have to be considered meticulously as indicated by this court in so-and-so cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case where the order of approval merely stated that government had meticulously considered the matter by use of the term so-and-so. Thoroughly checked, my lord.
Thoroughly checked.
Thoroughly checked. The relevant portion of the order reads as follows, my lord. So, my lord, this is a 6-page order. It considers everything. And I am, my lord, showing to your lordships and in my respectful submission, my lord, satisfactorily, that there is an application of mine. My lord, now please come to, my lord, page 24. Para 28, State of Maharashtra versus Ishwar Piraji Kalpatri. My lord, what documents should be scrutinized at the stage of sanction? This is 19, the sanction under 19, my lord, precognizance. Another reason as given by the High Court for quashing the sanction was that the order of sanction was signed by Additional Chief Secretary to the Government of Maharashtra, but there is nothing in this order to indicate as to whether the signatory or any other officer on his part was the one who had personally scrutinized the file and arrived at a subjective satisfaction that is a legal prerequisite. We do not find any warrant in law which requires a statement being made while according sanction that the officer signing the order had personally scrutinized the file and had arrived at the required satisfaction. They might say that the governor asked someone else to prepare the charts. He can do that, my lord. Any authority can do that. That this kind of clerical exercise of bifurcating in 3 different compartments, you give it to me so that I can easily make up my mind. Then, my lord, para 12. This prima facie shows that there has been an application of mind and that the material on record has been examined by the officers concerned before according sanction. In view of the aforesaid, there was absolutely no justification for the learned judge to observe that any such statement as indicated by him was required to be made in the order. The learned single judge made observations to the effect that the manner in which the sanction order has been passed would show that a rather cavalier treatment has been meted out in the present case. We do not see any justification for the court making such observations in the present case because the perusal of the order of sanction does not show any legal infirmity, etc., etc., my lord. My lord, then on principles of natural justice, my lord, page 25, para 31. My lord, I need not read this.
Celebrated judgment, Ramji.
Yes, my lord. So I know, my lord, your lordship would be aware. I placed it for immediate reference. Your lordship may not have to try and find out, my lord. Therefore, I'm not reading it, my lord.
Para
Even-
13 of that judgment.
Yes, my lord. Yeah, my lord, we have quoted
Truly
that.
horse or
And we have quoted 24, my lord.
24.
Yes.
Para 24.
Ramji, yes, my lord, 13. I'm sorry,
Ah,
your lordship,
yes.
sorry. I'm not, my lord, then, my lord, I'm coming to the next limb that in administrative action, there is no hearing required. I have already made my submission broadly that 17A is a stage where a very, very broad and prima facie view is to be taken. Whether it needs investigation, then you have all the remedies. Once the FIR is registered, you have the remedies and with which the approving authority, approval granting authority is not concerned. At times, it might happen that if an opportunity of hearing is read into the provision, the act, the object, intent and purpose of the act frustrates. The person might, my lord, destroy the evidence. And in any case, by the very nature of the power under 17A, which is purely executive and administrative in nature, Lord, no hearing is necessary. Lord, for that, my lord, I wish to, my lord, cite Subramaniam Swami, my lord, at page 27, para 36 at the foot, my lord. They have also cited, but my lord, this is the true ratio which is applicable in the present case, my lord. My lord, in fact, we got very substantial assistance from the judgment compilation filed by them. Para 44 of my lord Subramaniam Swami. We may also observe that grant or refusal of sanction is not a quasi-judicial function, and the person for whose prosecution the sanction is sought is not required to be heard by the competent authority before it takes a decision in the matter. This is for 19,
19.
much higher threshold, because the court is taking cognizance.
17A was not there at all.
Was not there at all, my lord, because it was introduced in 19, my lord.
2018.
18, my lord.
Yes.
Yes, I stand corrected. I am obliged. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency, prima facie disclose commission of an offense by a public servant. Well, this deals with the argument that principles of natural justice are attracted at 17A stage. If it does not attract, even at the stage of 19, which is a higher threshold, where the court is taking cognizance, and therefore you are now an accused. Here you are only a suspect at 17A stage. 19 makes you an accused. Even there, you are not supposed to be. It's purely executive function, administrative order. Similarly, my lord, judgment of Deepak Chaudhary, my lord, only para 5, the highlighted part,
Yes, sir.
we find force in the contention. The grant of sanction is only an administrative function. Though it is true that the accused may be saddled with the liability to be prosecuted in a court of law, what is material at that time is that the necessary facts collected during investigation constituting the offense have to be placed before the sanctioning authority, and it has to consider the material. Prima facie, the authority is required to reach the satisfaction that the relevant facts would constitute the offense and then either grant or refuse to grant sanction. The grant of sanction, therefore, being administrative act, the need to provide an opportunity of hearing to the accused before according sanction does not arise. The High Court, therefore, was clearly in error in holding that the order of sanction is vitiated by violation of principles of natural justice. The second ground of departmental exoneration by the disciplinary authority is also not relevant. What is necessary and material is whether the facts collected during the investigation would constitute the offense for which the sanction had been sought for.